Right. Hi there, everyone. My name's Malcolm Johnson, and I'm the head of the Abuse Compensation Department at Lyme Solicitors. And with me here today is Natasha Akhtar, who works in my department. This seminar is designed specifically for advocates, and it's on the subject of safeguarding, which is, of course, something that's pretty much written into the DNA of advocates, because, of course, they were brought into being to safeguard children and young people. What we've tried to do today is to try to tell you something that you don't know, or give you information that you may find helpful as a toolbox. After this seminar has taken place, we're going to send you some detailed notes which talk about the various parts of the law which are set up to help you do your job. And we're very happy to receive any kind of input into this seminar. You'll be aware that this is the first of 7 seminars which will be going out each month with the help of our excellent marketing department. And they will be on a range of subjects, including care leavers' rights and how the family and criminal courts work and benefits and that sort of thing. So you're very welcome to attend further seminars, but this is the first one for this year. So without further ado, let's start talking. So here we are, the basics of safeguarding for advocates. Now, a lot of these will be very obvious to you, but let me just go over them. I think the golden rule, because advocates have specific training on safeguarding, is that you should always follow your organization's safeguarding policy, and you should always speak to your designated safeguarding officer. That may seem obvious, but to us here at Lyme Solicitors, we're dealing with a very wide range of organizations, and unlike advocacy organizations, some of them are not as proficient in the ways of safeguarding. And what we tend to find is that organizations who we come across who are not in the public sector particularly will simply sidestep their own safeguarding policy. They won't talk to anybody. They'll just think, well, we don't need to bring in this nuclear weapon of safeguarding. We can deal with it in-house. And that is a classic mistake that is made in safeguarding. So although it's an obvious point, we'll make it, you should always follow your organization's safeguarding policy and always speak to your designating safeguarding officer in any case, because you've got absolutely nothing to lose by doing that. The third point is that everyone needs safeguarding. Some safeguarding policies that I've seen only cater for children. Now, that's a very big mistake. And the reason why it's a big mistake is, well, even though an organization is dealing with children and young people can be adults, as we know. If you're a care leaver, you go over into 18 or whatever, you become an adult. But the point is that safeguarding is about vulnerability. It's not about your age. It doesn't stop at some magic time. And therefore, although safeguarding policies should be practical, they should be directed at the kind of work that the organization does. It's really important that they cover both children and adults. And we'll be looking at the law behind that shortly. Never assume that information is shared in the same way. So a child or a young person may say to you, well, I've already told my social worker about this, already had a conversation about it. You don't need to say anything. You can't assume that that's the case, because very often information is shared in a different way. And particularly if you're very young, you won't have the same concept of communication as, say, an adult will. And it's very important indeed, if a communication is made to you, a disclosure is made to you that you think is a safeguarding concern, you cannot take the child or young person's word for it, that they have shared it in the same way with somebody else. You have to follow up on it. The next point is that safeguarding can be a powerful advocacy tool. Now, this is what advocates do. They were brought into being, particularly those under the Children Act 1989. They were brought into being in order to safeguard children. They are another voice. They are another ear, if you will. And so consequently, it is what you do. It is something that is wrapped up. But safeguarding can be used as a tool, because if a young person comes to you and says, well, I've got this particular problem, I'm concerned about this particular person who's putting pressure on me, you may be able to use that not only to take that pressure off, but also to get other outcomes for them, because it's actually quite a powerful tool, because it's one that local authorities have to respond to. What we tend to find is if you go to authority, you say this is a safeguarding issue, leaving it or brushing it under the table is effectively a big no-no. They have to do something about it. If they don't, they're in a lot of trouble. So it can be a very useful tool. Confidentiality, Natasha will be talking about that later, but don't worry too much about confidentiality, because the law is designed to protect you. It's not designed to gag you or to keep you quiet. It is designed to let you speak and to disclose things. Follow up the safeguarding concern. So you may have a safeguarding concern, and whoever it is you report it to, maybe the LADO, local authority designated officer, it may be somebody, it may be the child's social worker. It's always important to follow it up. Although people in local authorities are very professional about this sort of thing, you can never assume that it will be passed on. And sometimes, for whatever reason, it is not. So it's always a good idea, in order to provide a good service to that young person, that you follow it up. Be aware, as I'm sure you are, that abuse can take many different forms. It can be financial, it can be emotional, it can be physical, it can be sexual. And sometimes it is very subtle, because as we know, abusers behave in very subtle ways. For instance, grooming. Don't accept any sidestepping of safeguarding duties. So you may report a matter, might be to a local authority, and the local authority says, well, that's not really, that's not really a safeguarding concern, or it's not really my job to report this, or I can't assess this as a safeguarding concern. If you believe that it is a safeguarding concern and you're backed up by your designated officer, then you need to put it through. And the way to do it, in my experience, is to spell out what the consequences are if it's not, because it's when people talk about consequences that all of a sudden the importance goes up tenfold. A lot of the cases that we deal with here at Lyme are all about failure to pass on safeguarding concerns. That's really what most of them are actually about. The consequences are really quite devastating, and they may take 10, 20, 30, 40 years to come out. But when you're dealing with a person in care, that concern is going to be immediate. And finally, make sure you know what an adequate safeguarding response looks like. Now, we will be talking about that in some detail, but it may be for you to ask, well, is this really the right sort of response to this safeguarding issue that we need? So that's really our top tips. And Natasha will now take us through the next one.
Yes, hi everyone. So in this section, we're just basically going to be defining safeguarding and child protection. So the difference in the definitions, and I'm sure that you are all aware of the definitions, but I just thought we can quickly run through that. So later on, we're going to be looking at the Independent Inquiry into Child Sexual Abuse, which is the IICSA for short. Which basically had evidence from a large number of institutions in England and Wales who had looked after children over many decades. And their final report was published in 2002. This report basically noted the difference between safeguarding and child protection, because they were pretty much regarded as one and they were kind of welded in together. But there is actually a small distinction that needs to be noted. So safeguarding is protecting the health, the well-being, and the rights of people to live free from abuse and enabling them to have the best possible outcomes, whereas child protection is part of the safeguarding process, but it focuses on protecting individual children. So that's the difference between both of those definitions.
Thank you, Natasha. Now we're just going to take a very quick look at who the abusers are. Now, I'm sure all of you will be well aware of who they are, so we'll run through this very quickly. What we know about abusers, we know that they're predatory. We know that many are highly plausible. We also know that they're driven as well. They're like little clockwork toys. They circle around a particular vulnerability and they will carry on for a very long time. That's certainly our experience. They are people who are prepared to take a huge risk. They are taking a huge risk because, of course, if you are prosecuted for abusing a child, you are probably looking at a custodial sentence, not always. So these are people who take huge risks. They rely on secrecy. They rely on silence. Silence is one of the most pernicious fruits of abuse, as one High Court judge once said. They're highly manipulative, and they're also experts in blurring boundaries. So they'll say, well, you know, she was 15 years old, she knew what was going on. That's the kind of thing, but they'll blur boundaries in other ways and say, we don't need that check. We don't need these sorts of checks. We don't need this kind of safeguarding. That's what you'll tend to find. And it's always a very subtle process. And once again, in the cases that we've seen, we see that abusers are very good at manipulating those in authority above them so that things are missed and therefore they can carry on, basically. And we all know that it can be just about anybody. I was looking when I was preparing this lecture at a safeguarding leaflet written in the 1970s, would you believe it? And it was entitled Stranger Danger. And on the front cover, it was promoted by Mr. Jimmy Savile. Now, we've moved a long, long way since the 1970s, but that rather sort of sums it up. All abusers tend to be somebody who is known to the child or young person. Most don't. They are very rarely strangers, and I'm sure we all know that. So let's move on very briefly and just look at abuse and harm. Natasha.
So when we're looking at the definitions of abuse and harm, we're looking at the two key toolboxes which are used by social workers and advocates. So these are Working Together and the Guidance to the Care Act 2014. Appendix A of Working Together and the sections 14.16 onwards of the Guidance to the Care Act 2014 contains a number of detailed definitions of abuse and harm in a wide number of situations. So advocates should be alert to the following risks, and these are listed on the slide as well. So sexual abuse and exploitation, people abusing a position of trust that they hold, bullying or harassment, cyber abuse, discrimination on any of the grounds in the Equality Act 2010, which is the basis and the framework that we rely on, domestic abuse, self-neglect, physical, emotional abuse, extremism and radicalization, forced marriage, and modern slavery. So we live in a fast, modern, moving society where basically the definition of harm changes regularly because there are lots of things that are added on. Many cases that we deal with at Lyme Solicitors deal with emotional abuse. That's something that's very quickly progressing because, as Malcolm said, abusers now use a very subtle form of abuse, and physical, sexual, all of those things, yes, they are still prevalent in today's society, but emotional abuse has very much taken over because of how subtle it is and how it can barely be picked up on sometimes. And in a lot of cases, the failure to care cases, they really are not picked up on as much, and children are unable to communicate the harm that they're being faced with through emotional abuse because it's just not as prevalent to them. So it's as well as when we're dealing with grooming cases, there's a lot of cases where people are like teachers are abusing their position, and they're basically texting children, which is completely a violation of safeguarding as well. So in our experience, the police do not prosecute emotional abuse as well as they should, and obviously that still needs some work.
Just touching on what Natasha said, I mean, that is a major concern because, of course, when we take on cases, we're often dealing with a mixture of abuse, which would be sexual, physical, and emotional. But increasingly nowadays, we're getting emotional abuse cases, and our experience is that the police simply won't prosecute them at all. So we have a case against a school where most of the abuse that went on was emotional abuse. And this did an awful lot of damage, psychological damage, as much damage, we would say, as any sexual or physical abuse. But we find it very difficult to get the police to look into something like that. I think a local authority certainly would be concerned, but that is something that we're experiencing on the ground right now. Please don't panic if you're hearing all these things about Care Act, because you will be getting notes basically which spell out what the different parts of the legislation are and they explain them. So let's talk about the legal framework. So certain organizations are subject to a legal framework, and that means that they have to safeguard. So the law says if you are one of these organizations, you have to safeguard. You have to have a safeguarding procedure, you have to have a policy, and you have to carry it out. Now, not all organizations are covered by that. So for instance, if you are a private organization, you may not be under any kind of legislation at all. If you're a charity, the Charities Commission say, well, you've got to have a safeguarding policy and you've got to safeguard young people, etc., etc. But by and large, it is statutory authorities who actually come under the black letter law. So for children, we have Section 11 of the Children Act 2004. Basically, what that says is they said that if you're one of these organizations, you have to have arrangements in place to safeguard and promote the welfare of children. And that applies to local authorities, the NHS, the police, prison service and probation service, and organizations within the education and or voluntary sectors. So now there's a number of other similar duties as well. So for instance, the Home Office has duties to protect, for instance, unaccompanied minors, basically. We now come to adults. Is there a safeguarding framework for them? And the answer is yes, there is. And it's Section 1 of the Care Act 2014, which imposes a duty on local authorities to promote that individual's well-being. Now, these duties, like the Children Act 2004, can also apply to other organisations, such as the police and the NHS, a charity delivering Care Act duties on behalf of a local authority. So, moving away from the Care Act and the Children Act 2004, we then have guidance. And that guidance tells you in detail what it is you have to do by way of safeguarding. Now, for children, the main document, particularly that social workers use, but it's intended for other organizations, is Working Together. So the last version was published in 2018. And that is statutory guidance. It's got a Welsh equivalent, and it makes it clear that everyone who works with children has a responsibility for keeping them safe. The Care Act 2014 also has its own guidance as well. And it's written in pretty much plain English. You can use this guidance if you look at it. It's available on the website. We give you the links in our notes. But if you look at the guidance to the Care Act, it says in clear terms what it is that a local authority is expected to do where they have a concern about an adult, say. And finally, if you're a charity, Charities Commission says you've got to have a safeguarding policy. And charities actually have got into trouble because they haven't safeguarding. One example is Oxfam. Oxfam were held not to have safeguarding children overseas. And as a result, that had catastrophic consequences. Their funding got taken away. It had all sorts of problems, basically. But if you're working for a local authority and you're working for the NHS or an advocacy organisation, these are the main bits of statute and statutory guidance which are going to be setting out precisely what safeguarding is all about. So let's look now at legal tools, which is statutory guidance. This is a statutory guidance for children. So working together to safeguard children, also known as Working Together. So that's been with us since the 1970s. The last version is in 2018. I'll just talk briefly about it because I'm sure you're familiar with it, but it's also always worth reading as to use as a toolbox. But Appendix A of Working Together has a very useful glossary. And Appendix B has a list of sources of guidance issued by the government. Now, these sources are always changing, but if for instance, you have a safeguarding issue, so let's say, for instance, you're not satisfied that the local authority or the police are doing what they should, the place to look is this guidance because it may actually tell you what they really should be doing. And Chapter 2 of Working Together talks about the organizational responsibilities of different types of organization, which include voluntary, charity, social enterprise, faith-based organizations, and private sector as well. So it's a pretty key document when it comes to safeguarding. Let's talk about the statutory guidance for safeguarding adults. So the Care Act 2014 is a statute, that's the act, And then there's guidance. And the place to look is the guidance. And the Act is quite difficult to read. It's quite difficult to understand. It contains the core duties, which can be helpful if you're doing an email or a letter to a local authority. But it's a guidance that actually tells you what they're actually meant to do. And at section 14.7, we've got a ready-made definition of what safeguarding for adults means. So this is something that you can use if you need to. There's another section which is called 14.3, and that sets out 6 key principles that underpin all adult safeguarding work. So let's say you've got a problem. Let's say you've got somebody saying, well, there's not much we can do about this particular adult. It's section 14.13 and section 14.7 that may be very useful in you persuading, for instance, a local authority or somebody else that they need to act. So Natasha's now going to talk about a very important statute, which is the Data Protection Act.
So data protection is basically, as you probably know, relates to the holding of your personal data and the protection of your personal data. So obviously everyone is entitled to the protection of their personal data, and breaching that can be a very serious matter for any organization providing advocacy services. A data protection breach could lead to a heavy fine from the Information Commissioner or an action for damages. However, the law has long protected people who are engaged in the process of safeguarding, where information sharing is absolutely fundamental. The statutory guidance specifically says that poor information sharing in cases of suspected abuse can mean the difference between life and death, and it emphasizes the importance of full disclosure, not non-disclosure. The Data Protection Act 2018 is not a barrier to information sharing, and it should not be seen as such. It basically allows the spreading of information in certain circumstances, but it just gives it a bit more protection as compared to how it was before. So paragraph 2A of Schedule 11 says that the bar against dissemination does not apply to the prevention and detection of crime, which would include safeguarding procedures. The latest guidance for this is information sharing advice for practitioners providing safeguarding services to children, young people, parents, and carers, which was published in March 2015. And this is a 16-page document, which we will be sharing within the detailed notes that we'll be sending you after the webinar. It basically is talking about data protection. It's not written specifically for advocates, but it does explain the statutory basis that protects them when they make a disclosure. So the guidance sets out 7 golden rules for sharing information. And page 6 of that says, poor or non-existent information sharing is a factor repeatedly identified as an issue in serious case reviews carried out following the death of or serious injury to a child. In some situations, sharing information can be the difference between life and death. Fears about sharing information cannot be allowed to stand in the way of the need to safeguard and promote the welfare of children at risk of abuse or neglect. So that is always going to be the priority, regardless of the laws that have been put into place.
Thanks. And as Natasha says, I mean, the thing about the Data Protection Act is we as solicitors are absolutely terrified of the Data Protection Act. And the reason for that is that although we do actually carry out some safeguarding because our claims are the disclosure, which sometimes have to be acted on. In fact, often they have to be acted on by the institution, but you should not be terrified of the Data Protection Act. And if you read the guidance, which is not very long, it's only 16 pages, it's designed for people like you, and it makes it very clear right from the off. First point, it's designed to protect you. It's designed to let you speak. It's not designed to gag you at all. Otherwise, safeguarding would be quite impossible. But the other point is, to which Natasha alluded, is that information sharing is what it's all about. And the reason why people die, and they do die sometimes, is because of poor information sharing. That's repeated in a number of inquiries, right from Victoria Climbié right up to date. So just be aware of that. The guidance is designed to help you. It's not there to hinder you. So let's look very briefly at the proper responses of a local authority to safeguarding concern. And we've alluded to these documents already, but I'll just go over them again. It's the Children Act 1989 is a statute, but there are what we call volumes of guidance which are attached to the Children Act. And sometimes when advocates ring me up and they ask for advice, I will actually refer them to the guidance. Now, the guidance isn't specifically about safeguarding. What it actually does is it tells a local authority what to do in a particular situation. So, for instance, children who are in foster care, children who are transitioning from children to adults, that sort of thing. But it's written with safeguarding in mind. It's written to protect them. This is how wide it goes. And so that is actually sometimes a very useful source as to what the local authority should be doing. We've got working together, which we already talked about. We've got chapter 4 of the guidance to the Care Act. And then we've got specific sections in the Children Act. Now, sections 44 and 44 and 47, sections 44 and 47. 44 is the section that allows a local authority to take a child into care in an emergency. Section 47 is the power that allows a local authority to institute an investigation. So if they have a concern about a child in their local authority, section 47 is their investigation. Now, in my experience, they don't always exercise section 47. They may do something more low-key, which isn't necessarily wrong at all. But these are just two examples of the specific statutory powers that they have to actually find out what's going on and to protect a child. They have a whole range of powers, right from Section 20, for instance, accommodation order, all the way up to a full-blown care order, which they may exercise. And it doesn't have to be a care order. Safeguarding is not about taking children into care. It is effectively improving their outcomes, protecting them if need be. So the Children Act gives them a whole wide range of things to do. You then got sections 42 and 43 of the Children Act. Now, 42 and 43 are effectively the equivalents to section 47. 42 allows a local authority where they suspect that something is going wrong with a vulnerable adult to actually go in and institute an investigation, so they can do that. Section 43 is something different. What section 43 does is it obliges local authorities to set up multi-agency arrangements, and these multi-agencies are known as safeguarding adult boards. So the whole ethos behind the Care Act 2014 and indeed the Children Act 2004 is that local authorities have to work together with the police, the NHS, voluntary organisations, charities, and time after time the lesson is that where these organisations do not talk together, that's when you will find children coming to significant harm. So that's section 42 and section 43. And then we've got the police, and the police can actually remove a child under section 46. So the law provides a pretty wide range, but the question is the local authority or these other organisations, are they going to exercise that? Is a chain going to follow through where the child is protected? Now, sometimes that process gets stuck, and that's where you can come in and say, well, why is it then that we haven't instituted a section 47 investigation? Why is it that we haven't instituted a section 42 investigation when there's clearly an issue here? Reminding local authorities, reminding statutory organisations of their statutory duties often works very well because, of course, they are required to comply with the law. And very often they do, but unfortunately there are cases when they don't. The final thing to talk about is the way that the police act. So when the police investigate, and they don't investigate every suspected safeguarding issue, but when they do, they are required to gather evidence in a particular way, and that means using something called Achieving Best Evidence, which is a manual that says how you investigate not only children, but also vulnerable adults as well. And you'll find that in the notes. The LARDO. What on earth is the LARDO? Well, very briefly, the LARDO is the local authority designated officer, and they are somebody set up under working together. So the LARDO only works in relation to concerns about children and only in relation to cases where there is suspected abuse by people working with children. So it wouldn't normally apply to, say, friends of a child or, say, relatives of the child. Now, I have known cases where LADOs have actually done far more than that, but technically speaking, that is what the local authority designated officer does. And if there is a safeguarding concern, that is the person to whom you go, effectively. But just note that there is a restriction. I'm sure that you all do this, but there is absolutely nothing stopping you having an informal chat with the LADO, having an informal chat, in fact, with anybody who is concerned with that particular child. And there is actually a national LADO network as well.
Okay, so who should you approach within the local authority if you have a safeguarding concern? So if there is an allegation and you need to be reporting that to a safeguarding authority, then normally you should approach the social worker for the child or adult. If there is no social worker, then you need to approach the child or adult social care team. It could be that you already have a contact that you can contact directly. The local authorities also publish details on their website of who to contact if there is a concern regarding an adult or a child. And there is also nothing to prevent an advocate from having an informal chat with a social worker.
Okay. Now we've only got two more subjects to cover. One is about the disclosure and barring service, and then the final one is about ICSA. So we'll do those briefly. So the Safeguarding Vulnerable Groups Act 2005 and the Disclosure and Barring Service is effectively what underpins checking people out. So when people want to come into organizations and work with children or vulnerable adults, then they have to undergo police checks. So we'll just look at this very briefly indeed. Now, this system has been around for obviously a very long time, and it's been fine-tuned over the years. In the context of safeguarding as an advocate, it's not something you need to worry about too much, but just be aware that it's obviously, you know, that it's there, the way that it works. And know that ICSA, the Independent Inquiry into Child Sexual Abuse, has recommended some changes, but they're not very far-reaching, I have to say. In my experience, the checking of people doesn't tend to lead to much in the way of safeguarding concerns. I think where you get problems is where there are delays in checks coming through, and it means that people are hard and they start working without actually being checked, which of course is quite wrong. And I have seen organizations pulled up over that. But by and large, that's what that is about. Now, the final thing that we're going to look at is the Independent Inquiry into Child Sexual Abuse. So this started in around about 2018 and it ended in 2022. Now, it heard evidence from a wide variety of organizations. It heard evidence from schools, local authorities. It did inquiries into children in all sorts of residential settings. And it came out with a number of recommendations in relation to safeguarding. So first of all, there are a number of key lessons. First of all, they said that certain organizations had a nice, shiny child protection policy, but they never implemented it. They just kept it in a drawer somewhere, forgot about it, and then just carried on their own merry way. And that actually happened, basically. One of the problems that they recognized is that local authorities, and indeed organizations which carry out safeguarding like advocacy organizations, have a well-rehearsed process. So they know what to do. It's in their DNA. Private organizations, particularly schools, aren't well rehearsed. And sometimes we come across cases where it is clear that this particular school, this particular institution has never actually run a safeguarding process before. They've always managed to sidestep it. And that means that we have to apply quite a lot of pressure to get them to do what they should be doing. So that was something else. They also identified that statutory inspection does not always identify poor practice, and that's often been a problem, particularly with Ofsted. They also said that keeping allegations of abuse in-house was disastrous, basically. And there was always a risk that institutions would backslide. In other words, they have a safeguarding process, they do their training, and then all of a sudden it's all forgotten about, and then they revert to previous practice. So ICSA contained a number of recommendations, basically. Now, you'll see these recommendations in the notes, but one of the things that they said, and one of the things that could possibly affect you, would be the introduction of mandatory reporting. Now, what is that? Mandatory reporting means that if you fail to report an allegation of abuse, it could be against a child or an adult. The legislation has not been put in place yet, but if you fail to report that, they prosecute you. You could go to prison. Now, in other jurisdictions, particularly the United States of America, people do actually go to prison for not reporting things. It does happen, which gives you some idea of how it might play out in this country, that it won't be something that, you know, never actually appears in a Crown Court. It will be something that actually happens. Who will mandatory reporting cover? Well, at the moment, what the government is about to do is to introduce a consultation process whereby they will say to various organizations, well, what do you think about mandatory reporting? And of course, some people say there should be far more. Some people will say it's going to be very difficult for social workers, going to be very difficult for advocates, basically, to be under this duty. We'll see what the government do. We don't know who it will cover, but I think that it will probably cover anybody in a regulatory activity. And what that means is that if we come back to the Safeguarding Vulnerable Groups Act 2005, it's anybody who is working with children and vulnerable adults. So anybody who has to police check their employees will come under this particular duty. That's the way I think it will play out. But I think we are at least 2 years away from seeing anything on the statute book. Okay. We have now finished our seminar. Thank you for your patience. And now Natasha and I are ready to answer any questions. Please be aware that, as I often say to my staff in my department, there is no such thing as a stupid question, because I find myself asking stupid questions every day of my professional life. So if you have any burning questions, and also just one other thing, and it's this. We do help advocacy organizations. We also help local authorities from time to time. We're not bothered who you are or where you're from. We run a free surgery every month, but I'm always open to somebody who wants to ring up or email and say, look, Malcolm, I've got this particular problem. Now, I may not be able to help you, but over the years, we've developed quite a body of expertise around children and care leavers, which is specifically designed to people like you. And so if you want to send an email and say, well, look, I've got this particular issue, particularly if it's something around the complaints procedure, but it might be something else, feel free to email me, and I will do my best to help you, and it won't cost you a thing. So without further ado, do we have any questions from our floor at all?
Hi, Malcolm. So we have our first question, which is, what in your experience is the most common safeguarding mistake that is made?
I think the most common safeguarding mistake that we see it in private organizations, but the most common safeguarding mistake is failure to follow your safeguarding process. So you just simply ignore it. And the classic example of failure to follow safeguarding is Ampleforth School. So this is a very big private school in the north of England. And they started having a lot of safeguarding disclosures being made from round about the early noughties right up to date. And they had a lot of claims made against them. And they were told to put in a safeguarding policy. And over the course of the next 2 decades, they repeatedly showed themselves incapable of following their safeguarding policy. And it got so bad that Ofsted said to them, you cannot take on any new children. Can't have any new children at all, because the children are too much at risk. And that's how far it can go. But that's the most common safeguarding error. It is not following your safeguarding policy at all. Simply, I saw another case against a school where In every safeguarding policy, you will have designated officers. So you have people who are senior in the organization. The idea is that those senior people are not necessarily people in authority. They are just people who know more about safeguarding, basically. They're the sort of the guru, if you will. And what we've found is that a senior person within the organization will sweep all that aside, walk in and say, well, I'll deal with this safeguarding concern. And what happens to the safeguarding concern? They say, well, it's not something that we need to refer to the police. Or they'll say, well, it's anonymous. It's not something that we need to investigate. It's sidestepping your duties, taking the easy way out. I think that's probably the biggest mistake that we find.
Thanks, Malcolm. The next question is, in relation to the changes recommended by the independent inquiry into child sexual abuse, which of the care professions will become subject to mandatory reporting?
Well, I think that it'll be everybody who, for the purposes of a Safeguarding Vulnerable Groups Act, is involved in what we call a regulated activity. So if you're in a regulated activity, you're working with children and vulnerable people. So effectively everybody who works with children and vulnerable people will be, because I couldn't see the point of limiting it, say, to the two classes of people who work with children all the time. They are social workers and teachers. I don't think that would work, because why should it be only them who are subject to this duty when there are so many other people who are working as well? So I think what they'll do is they'll pin it to the definition of regulated activity. So if you have to police check any new employees who come into your organization, then you will be under the duty of mandatory reporting. I think that's what they'll do. That's my own view.
Thanks, Malcolm. We have one final question, which is, what are the consequences of failure to safeguard now?
Well, it has different layers or different tiers of safeguarding failure, but the worst consequences is consequence for the child or the young person or the vulnerable person, which at the very worst, although this is extremely rare, is that they basically die. So if you talk to any local authority up and down the country, they will have every year what used to be known as, 2 or 3 serious case reviews. So these are cases where children have come to some massive harm, and that's something that happens all the time. And it may not be the local authorities' fault at all, but the first consequence is a harm to the child or the vulnerable adult. That's going to be the first thing, and of course this can go on for many years. So that's the first consequence, and the most important consequence, because that's what safeguarding is all about. But the other consequences of failure to safeguard are the organization for whom you work becomes damaged, and this applies to both public and private authorities. So let's say that you are a charity, you're looking after children, and you fail to safeguard. It's what happened to people like Oxfam. It's what happens to people like Ampleforth. All of a sudden, your funders stop funding you, start keeping their distance, and we're not sure about giving you the money anymore. You may be government funded, you may be local authority funded. For instance, we've got the example. I've forgotten the name of the organisation, but some years ago there was an organisation, I think, working mainly in South London. They were funded by the government, received millions of pounds, and eventually I think they went bankrupt because they were taxed. But that, to my mind, was a safeguarding issue, because of course, if they were badly financially run, well, what does that say about what was happening to all those people that they were helping, all those children? So the consequences for the organisation can be very serious indeed. And those are the two main ones. It's effectively the consequences for a young person or a vulnerable person, whatever it may be, but it's also the consequences for your organisation and for you professionally as well. I mean, very often these things are never reported in the press. They can't be, because we have to keep all these details anonymous. That's the law. but the consequences are extremely serious. So those are the two levels of what we tend to see. Okay, no other questions. So as I say, thank you very much indeed for listening. And if you have any issues arising out of this seminar, or you'd like to ask me anything more, please feel free to ring us up. Our details are on the slides, and you will be receiving notes. And of course, but thank you all very much for listening.